What was really in their mind during the crime?
Hi, my name is Christie Fram and I'm an attorney here at the Nieves Law Firm. And today I'm going to be discussing with you what is intent in criminal law. Intent in criminal law refers to the mental state of the individual that is committing a crime. It answers the question of what is going on in this person's mind when they are allegedly committing a crime. There are generally two types of intent. There is general intent and there is specific intent. For general intent, the prosecution generally has to just show that the individual that allegedly committed the crime intended to commit the act regardless of the outcome, without any intention of achieving a specific outcome. An example of this is battery. Battery is a general intent crime. And what that means is that, for example, there are two individuals. One person is screaming at the other person is getting frustrated because they're being yelled at. And so the frustrated person pushes the person that's yelling. That person that pushed intended to commit the act of pushing the other person. However, say this person that was pushed falls to the ground, hits their head, and they're now profusely bleeding. So the person that pushed the other individual did not necessarily intend for the outcome that resulted, which is the individual hurting their head severely and profusely bleeding, but they did intend to push the other person. That's all that is required to prove a general intent crime. The specific intent crimes are slightly different. Prosecution is required to prove beyond a reasonable doubt that the individual that allegedly committed the crime intended the act and intended a specific outcome, or the outcome that resulted. An example of a specific intent crime is burglary. Burglary requires breaking and entering, that is the act. However, it also requires the mental element beyond a reasonable doubt that this person intended to break and enter for the purpose of theft or to commit a felony. As indicated earlier, the prosecution must prove beyond a reasonable doubt that the individual that allegedly committed the crime acted with specific intent to achieve the outcome of the act. So whatever that outcome resulted in. There are several ways to negate the intent that is trying to be proven by the prosecution, and that could be lack of knowledge, that could be mistake of fact, it could be that you were under duress or coercion, somebody forced you to do the act, and which resulted in that outcome. So you did not willfully and knowingly commit the act for the purpose of achieving whatever the outcome may have been. There are several things that can be raised to negate the mental state that the prosecution is trying to prove. Another example of general intent is driving under the influence. The prosecution does not need to prove beyond a reasonable doubt that you committed the act of driving under the influence for the specific purpose of putting someone in danger. They don't need to prove that. The mere fact that the individual that is intoxicated got in the vehicle and knowingly operated the vehicle is enough to show that the person had intent. So if you or anyone you know is facing criminal charges or potential criminal charges, you do not need to do it alone. So please feel free to reach out to our firm. We'd be happy to help guide you through the process.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.